this topics based on the separation of powers. And when you look in the previous questions, when you look at the previous questions, they are based on both theory of separation of powers as well as actual implementation of how the separation of powers are executed at the union level and state level also. So means there are equally the questions about the president, prime minister, and council of ministers, as well as governor and the chief minister at the state level. So there was also a direct question about how president enforces the financial emergency and implications of the financial emergency. So a direct question, what are the reasons for enforcing the financial emergency and the consequences of financial emergency, like that. So, so here we go with the executive and judiciary, because there is a separate topic on parliament and the state legislatures. And a couple of questions can also be asked about the ministries and departments of the government. So to start with, as always, it is a controversial matter. Like judiciary should be independent and it should reflect in the judicial appointments and in the appointment of the retired judges. So this is not about retired judges being appointed as the judges of the Supreme Court. It is about retired judges being appointed for various other positions after the retirement. The post-retirement benefits given by the government. There are two things actually. A retired judge of the Supreme Court can be appointed as an ad hoc judge by the Chief Justice of the Supreme Court. And this question is about a judge who retired being given other positions in the government. Something like Ranjan Gogoi was being given the Rajya Sabha membership. And earlier, a governor was, Chief Justice was also given the post of a governor. So if this post-retirement benefits are given, it would be a compromise with the independence of the judiciary. So judiciary should be independent of the executive, basically. And
Ranjan Gogoi pair, example. Ranjan Gogoi pair also.
Right, no problem. Because it is truth, factual element, and it is not a matter of controversy as well. So judicial independence, that means judiciary should be independent of executive. Often judicial autonomy is compromised by the executive. The judiciary by itself is not compromising with the, it is because of the office given by the executive that the judicial independence is at a stake. And independent judiciary is ensured in the process of appointing the judges. And that is the appointment of the judges by a higher authority, prescribing the higher qualifications. That is, a judge to be appointed should be having 5 years experience as a High Court judge, or 10 years experience as an advocate of a High Court, or he should be an eminent jurist. And salaries being kept out of the control of Parliament from being reduced. The Parliament can increase the salaries but not reduce the salaries. So therefore, the Chief Justice is getting almost 2,80,000. Ordinary judges are getting 2,50,000 salary. Difficulty in the dismissal of the judges. It will be very difficult, and even if you look at the procedure of dismissal of the judges, it is like a procedure of protecting the judges rather than dismissing the judges under the 1968 Judicial Officers Protection Act. So prohibition of post-retirement appointments for the offices of the prophet is also one of the requirements, and giving post-retirement postings to the judges is to be prohibited. So the need for independence, you should also mention about the need for independence. Why the judiciary has to be independent? So that the judiciary, in the judicial action, neither Parliament nor executive will dominate. And judicial freedom in the appointments was achieved by the court itself after the third judge's case. So where the court was prescribing about the idea of collegium in 1998. So, but however, the judicial independence was at stake when it recommended the appointment of Saumitri Sen and P.D. Dinakaran, who were facing the impeachment as well. Because this P.D. Dinakaran, who was the Chief Justice of Karnataka High Court, facing the allegations of occupying 1,000 acres of government land in Madras, in Chennai. And similarly, this person, Saumitri Sen, was also facing the allegations of corruption for manipulating the court money when he was the Chief Justice of Madhya Pradesh High Court. Almost he manipulated 30 lakhs of the court money. So there was a compromise regarding the judicial independence, offering the post-retirement benefits, like appointing Justice Sadasivan in the 5 months after the retirement as the governor of Kerala, and also Ranjan Gogoi being nominated as a member of Rajya Sabha. So not even election, it is only a direct nomination by the government. Ranjan Gogoi was important person who was delivering the key judgments in the cases, including Ayodhya. So, so there is a need for 2 interventions to restrict this possibility of offering the post-retirement benefits, at least to limit that the retirement age of the Supreme Court and High Court judges must be increased. And even the bill regarding that is also under pending. So it is said that the government may introduce this bill for increasing the retirement age of the judges after the retirement of the present Chief Justice. Because the present Chief Justice is giving judgments censuring the government more and more. So the government do not want the continuation of this existing Chief Justice. So therefore the government would introduce the bill to increase the retirement age of the judges of the Supreme Court and High Courts. And the present retirement age is 65, and it is proposed to be increased to 68. And similarly, the retirement age of the High Court judges should also be increased from 62 to 65. So an amendment to the statute setting up tribunals and commissions and manning them with professional cadre of tribunal judges. So the appointment of persons through the collegium and the restriction upon the post-retirement benefits, both have to be restricted so that the independence of the judiciary will be protected. So it will also go again is the clear demarcation of separation of powers. If these things are, if the judiciary is being not given independence. So this question is important from the point of view of the proposed bill to increase the retirement age of the judges, and as well as from the point of view of the a debate is being going on for reconstitution of the National Judicial Appointment Commission. So then the second question, there was never a balance of power among the 3 organs of government. Either executive is dominating the judiciary or judiciary is dominating the executive. Comment on it. So this is a theoretical question regarding the separation of powers with reference to the practical experiences that we are experiencing over a period of time in the Indian political system. So based on the theory of separation of powers, there should be a balance of powers among the 3 organs of the government. So this balance of power is achieved through mutual checks and balances. Legislature has to control the judiciary and executive. Judiciary controls the legislature and executive. Executive regulates the legislature and the judiciary. So all the 3 organs controls each other. But suppose judiciary controls legislature and executive through the judicial review. Judicial review of the parliamentary legislation and executive action. Similarly, Parliament controls the judiciary by impeaching the judges. Parliament controls the executive through no confidence motion or asking the question, making it accountable. Executive controls the judiciary through the appointments. And executive controls the legislature by dissolving the legislature. Possibility of dissolving the legislature prematurely.
Ordinance. Ordinance.
Huh?
Ordinance.
That is escaping the control. Ordinances is a way of escaping the legislative control by the executive. So this is about how executive controls the parliament. Executive controls the parliament by summoning the meetings or not summoning the meetings. Both the things can be done. Or by dissolving the legislature, that is the Lok Sabha. Anything can be done. So this ensures the balance of power among the three organs of the government. So in Indian political system, there was never a balance of power because the theory of separation of powers, as developed by Montesquieu, is clearly adoptable only in a presidential form of government, not for a parliamentary form of government. Because American Constitution is based on the theory of separation of powers of Montesquieu. So American system, how it is operating? The American system is operating based on the three fundamental formulas. Suppose Article 1 in the American Constitution empowers the legislature to make the laws. Article 2 empowers the executive, the president, to enjoy the executive powers. And Article 3 is empowering the judiciary to interpret the laws. So clearly, first three articles in the American Constitution are based on the theory of separation of powers. But in the parliamentary form of government, it is not possible to clearly demarcate the role of each of the organs. The reason is legislature and executive are together because executive has to maintain a majority in the parliament, and parliament is at the discretion of the executive only. So therefore, we cannot demarcate between the role of the legislature and executive. So they are together. Hence, it is possible for the government to dominate the judiciary, and sometimes judiciary is dominating the government. If you look at the history of judicial pronouncement over a period of time since 1947, at least from 1950 till date, from 1950 to 1967, the judiciary has never given a judgment against the government. So the first case of judicial activism was only 1967 case, Golaknath case. Till 1967, there was no judgment given by the Supreme Court censuring the government. So almost 17 years, it was almost like a inactive position. It was only for the first time in 1967 with the Golaknath case, a judgment was given against the government. So from 1967 onwards, the era of judicial activism has begun. And that has reached its peak with the 1973 Keshwananda Bharti case, in which the Supreme Court has sit with the largest bench ever. So that is 13 judges sat on the constitutional bench of the Keshwananda Bharti case. Of course, even the number of lawyers who fought the case were also the huge. Almost Keshwananda Bharti has engaged 40 lawyers in that case. And the Supreme Court has sat with 13 judges in that case. So that was the largest bench so far. And it is the biggest case of judgment given against the government. Thoroughly, the government has been censured by the court. Then, so various other cases. Till 1990s, the judiciary was in the, till 1980s, the judiciary was practicing the kind of, judicial activism. So the domination of the judiciary over the executive has been witnessed during this phase. And since 1980s, the activism has further grown into judicial overactivism. And after 1990s, the judicial overactivism has further grown up into judicial adventurism. So judicial adventurism means judiciary crossing beyond its limits, going beyond its limits and intruding into the jurisdiction of the government, in which it should not interfere at all. So this judicial adventurism is a tendency of judiciary to cross beyond the limits and even interfering into the activities in which it should not interfere. And this is most witnessed even during the COVID-19 time also. During the second wave of COVID-19, the court has taken up a series of cases, not only the Supreme Court. The Supreme Court has also encouraged the high courts to take up a series of cases suo motu against the government for the failure of the government action to protect the people. So almost 12 high courts were doing actively, were performing actively to censure the government, and continuously on a day-to-day basis, government was under the check by the Supreme Court as well as various state high courts at the state level. So every day it was taking the account about the deaths happening. It is taking count about the supply of medicines, supply of oxygen cylinders. So for every detailing that the court was interfering with the government. So that is an adventuristic role played by the judiciary during this phase. So either court is dominating the government or government is dominating the court. Either of the things is happening. So, so this is the way the failure of balance of power is existing. So in 1970, after 1973, Keshwananda Bharti case, the government has appointed A.N. Ray as the Chief Justice. And it was a break of tradition, whereby the fourth senior most judge being appointed as the Chief Justice. And that was the first incident where the Chief Justice is not a senior most judge of the Supreme Court. Similarly, in 1977, M.U. Beg was also appointed as the Chief Justice, who was second in the seniority list. And the peaks of judicial executive domination over the judiciary was witnessed after the fourth judge's case in 2015. So in the fourth judge's case, what the Supreme Court did, the Supreme Court has declared the National Judicial Appointments Commission constitutionally invalid. So after that, the retaliation has begun by the executive, because the executive was very enthusiastic to constitute the NJAC. And hence, personally, it was almost like a personal choice for the government to end the domination of the judiciary in appointing the judges through the collegium system. So a collegium is to be replaced with the NJAC, and NJAC to be comprising of both the representatives from judiciary, executive, as well as the legislature. So the Chief Justice is the chairperson of the collegium, the NJAC, and the ex officio members, two ex officio members will be the senior most judges of the Supreme Court. And one ex officio member is Union Law Minister, executive representative. And apart from that, the leader of opposition in the Lok Sabha is also a part of the NJAC. So though this body is a very seemingly very balanced body to appoint the judges, the court has declared this agency to be unconstitutional. So therefore, after this 2015 judgment, the government, the executive, has stopped appointing the judges of the Supreme Court, because Article 124 says the judges of the Supreme Court are appointed by the President. It is silent about if they are not appointed, what will happen. So the President is only supposed to appoint the judges. But of course, the President appoints the judges only if they are preferred by the executive. So executive is, that is the cabinet, is recommending the President whom to be appointed as the judges. But that power is being taken away by the Supreme Court through the collegium system. The power of appointing the judges by the executive is taken away, virtually taken away, without making any inroads into the constitution. There is no provision. In fact, collegium is like almost an unconstitutional body. So, which is against the principles of the Constitution, because even against the principles of the separation of powers theory. According to the theory of separation of powers, judges of the Supreme Court, judiciary, has to be appointed by the executive to ensure the balance of power, mutual checks and balances. Judges to be appointed by the executive, to be removed by the legislature. But through the mechanism of the collegium, the judiciary has started appointing its own judges. So therefore, the role of the government has completely eroded. And in 2015, from 2015 to almost 2021, for a period of 6 years, the government has stopped appointing the judges, which resulted in almost an escalation of the vacancies in the judiciary to the extent of 43%. Not only in the Supreme Court, but also in various high courts as well. Across the high courts in the country, 43% have vacancies have arisen. And even in Supreme Court also, out of the 34 judges to be there in the Supreme Court, almost 10 vacancies have arisen. So which is not a small number. 10 vacancies in the Supreme Court out of 34 is not a small number. So till 2021, the government has allowed to continue the vacancies arise. Only in 2021, 9 judges have been appointed at a time. And even this year also, a series of at least 10 judges are going to get retired. So we have to wait and see whether all these 10 judges would be appointed immediately or not. If the government wanted to continue the retaliation, so it need not appoint them at all. So as a matter of retaliation, this has been done, that letting the vacancies to rise, that's all. So therefore, the government is continue to dominate, showing the domination over the judiciary as well. So the executive, by holding the power of appointing the judges, can control the judiciary. And judiciary, through the judicial review, can control the executive. So this is sometimes the executive control over the judiciary, sometimes judicial control over the government will happen. So there is no supremacy of any organ like American Constitution or the British pattern. In the British pattern, Parliament is sovereign, and in the American pattern, Supreme Court is dominant. So in the Indian Constitution, it is happy to know that neither legislature, nor executive, nor judiciary, none of them are superior to any other. Anyone can dominate anyone. So suppose even during this second phase of the judicial history of India also, Parliament has enacted several legislation, several amendments to the Constitution to override what the Supreme Court was saying. Suppose after the 1973 basic structure concept, the Parliament has enacted an amendment to the Constitution incorporating Article 368 subclause 5 and 6. So this subclause 5 and 6 are indicating reducing the role of the judiciary and enhancing the role of the Parliament in amending the Constitution. So a basic structure was prescribed as a limitation on the power of Parliament to amend the Constitution. But the Parliament has overridden this power, overridden this judgment by incorporating this subsection 5 and 6 of the Article 368, which says that nothing can be a limitation on the power of Parliament to amend the Constitution, including the basic structure. It is an implication, not a specification. An implication is that nothing can be a limitation on the power of Parliament to amend the Constitution. That means Parliament can amend anything. And it also said that the amendments of the Constitution cannot be questioned in the court. So that is how the Parliament can also reign supreme over the judiciary. So in the conclusion, what we have to maintain is it is in the interest of the democracy, such an arrangement is existing. And it is necessary to have such kind of controversies among the three organs of the government. It keeps the democracy vibrant. If the democracy has to remain as vibrant, legislature, executive, judiciary, all the three organs should always be in a controversy with each other. That will result in emergence of the new ideas, emergence of the new jurisprudence, emergence of the new doctrines. Then the third question is how the post of governor is controversial in the union-state relations. So during the last few years, the post of governor is controversial for various reasons. Either because the central government is using the post of governor for establishing its own power across various states. Suppose starting with the Arunachal Pradesh, then Uttarakhand, Uttar Pradesh, Madhya Pradesh, Jharkhand. and Karnataka, now in Maharashtra also. And even in Telangana, it is a controversial power. The story in Telangana, Tamil Nadu, and West Bengal is different. So in the first listed states, governor was dominating the governments in the state. And in these three states, the chief minister was dominating the governors. So for either of the reasons, either governor is dominating chief minister or chief minister dominating the governor. In either of the cases, the post of governor is controversial. So usually the post of governor becomes controversial because of the service conditions of the governor. Service conditions are the appointment, removal, transfer of the governors. They're all controlled by the union government. And most often it is being politically manipulated and bureaucratically enjoyed. Most often we see the bureaucrats being appointed as the governors. The bureaucrats and the retired police officers, retired IAS officers are also appointed as the governors who are close to the chief minister while working in the PMO. Suppose earlier Governor Narasimhan was an IPS officer. He retired in 2005 on December 30th. And he was allotted a governor post in Maharashtra in January itself, in 2006 January. So very quickly he got the post-retirement appointment as a governor. This would not have been possible unless he was a part of he was having a lobbying mechanism in the PMO. So the governor's post is a politically beneficial post. And in the appointment, it is suggested that the chief minister has to be consulted. But chief minister is never consulted. Chief minister is only communicated about the appointment of the governor. And the removal, the governor has no fixed tenure. Though constitution is saying the governor will be holding the post for 5 years. The same constitution is also saying the governor will hold the post during the pleasure of the president. So the pleasure of the president means the pleasure of the prime minister. Therefore, whenever the government at the union level is changing, governors at the state level are changing. Suppose in 1989, almost 17 governors were dismissed and new governors were appointed by the VP Singh government. And in 2004, nearly 12 governors are dismissed and new governors are appointed. So this is how whenever there is a change in the union, government in the union, governors at the states are changing. And even the NDA government has forced the governors to resign, though there is a protection to the governor from the judicial pronouncement. Suppose in the previous class, I was telling you about BP Singhal case. In the BP Singhal case, the BP Singhal case was a judgment given by the Supreme Court in 2010 after the UPA government in 2004 has dismissed 12 governors. And when the 12 governors are dismissed by the UPA government, BP Singhal, he was a member of BJP, an activist in the BJP, and he filed a case in the Supreme Court. And the Supreme Court was giving the judgment in 2010, and where it was said that governor should not be dismissed at the sweet whimsical fancies of the government, because governor is neither an agent of the government nor an employee of the central government. So therefore, governor should not be removed at the sweet whimsical fancies of the union government. That was the judgment. So since 2010, the removal of the governor has almost been minimized. But informally, the government is forcing the governors to resign. The NDA government has done that in 2 cases, like dismissal, forcing the governor of Kerala to resign, forcing the governor of Nagaland to resign. The forcing is not like, it is just only every day the principal secretary from the Home Ministry used to call these governors to resign immediately. Suppose Sheila Dikshit was the governor in Kerala. So they were not ready to resign because there was a judicial protection to them after the change of government in 2014. So what the principal secretary was doing is he was daily in the early morning 5 o'clock used to call the governors and asking them and requesting them to resign. This happened almost 15 days continuously. And because of this informal pressure, they had to resign ultimately. So that kind of procedures are adopted by governments in one form or the other to get the governors removed. Though the court is saying that the governor is not an agent of the union, but still the government, either the Congress or the BJP or any other, are treating the governor only as an agent of the union. Therefore, it is a matter of controversy. And, and it is also a controversy because of the discretionary powers. The governor enjoying the discretionary powers in the appointment of the chief minister or in the dismissal of the government or dissolution of the assembly, ordering the prosecution of a minister. The prosecution of a minister, ordering for the filing a case against a minister will also require the approval of the governor. Governor can do this even without or even against the advice of the Council of Ministers. Suppose in 2011, in Karnataka, the governor has ordered the prosecution of the chief minister himself. Yediyurappa was ordered to be prosecuted by the governor. And recommending the president to impose Article 356 is another discretionary power. Again, is the intentions of the state government. Then reserving a state bill for the approval of the president. Every year, on an average, at least 2 bills from a state will be reserved. Every year, there will be at least 50 to 60 bills from the states are pending before the president, which are from the state bills act. Even suppose the Disha Act enacted by the Andhra Pradesh government. So which was intended to punish the culprits within 21 days. Was also reserved to the reserved for the presidential approval because it's a law enacted on the concurrent list. Though the Andhra Pradesh government has quickly enacted this law in the assembly, that bill was not approved by the governor because it's a bill on concurrent list. And any bill on the concurrent list would be reserved by the governor for the presidential approval. So it is yet still pending before the president. And most probably it would not be approved by the president as well. And fixing the dates, proper dates for trialing the cases would not be practically possible. Because they have fixed a specific durations, like 7 days for the investigation of the case, 7 days to bring the case to the to file the charge sheet, 7 days to give the judgment. So totally in just a span of 21 days, you have to clear the cases related to the rape and murder of a woman, that which is popularly described as the Disha Act. And this would result in misuse of the powers. Suppose if you are fixing a 7 days time to try to investigate the case, what will happen? The police may manipulate this opportunity to fix someone and to accuse someone as the accused. So therefore, such kind of laws would be flawed. And hence it was reserved by the governor for the approval of the president, and that is not yet enforced. And ordering for the floor test, as in Maharashtra in 2022. So the governor has ordered the floor test at a very quick time. And even the Supreme Court has also denied to interfere in this matter. So in view of these issues, the controversies, the recommendations of the Sarkaria Commission and the Poonchi Commission and the recommendations of the VP single case, they were all supposed to be followed to minimize the controversy of the governor's post. And it is not necessary that the post of governor should be abolished. Because even there was a recommendation about abolishing the post of governor by the Rajamanar Committee in 1966. Rajamanar Committee, a committee on center-state relations constituted by the Tamil Nadu government in 1966, that went even to the extent of recommending the abolition of the post of governor. And that is not necessary. And even the governor should be allowed to perform the constitutional obligation. All the time, it is not necessary that governor should only be criticized. We have been habituated for the past 70 years to criticize the role of the governor. Right. But it is not necessary that governor's role should be only criticized. Governor should be allowed to perform his constitutional obligations in a proper mechanism, through proper mechanism. So when these formulas recommended by Sarkari Commission or Punchi Commission are prescribed in the Supreme Court in the BP Singhal case are adopted, the governor will remain non-controversial. But suppose Sarkari Commission recommended that before appointing the governor, consult the chief minister. Not just communicating the chief minister. And what is happening is, after appointing the governor, the information is given to the chief minister. That's all. And consultation is different, because when you consult, you prescribe a panel of names to the chief minister. Names of 3 people will be given to the chief minister, and chief minister will be allowed to pick one of the 3 names. So that will avoid possibility of controversy between the governor and the chief minister. So apart from that, as the governor of Maharashtra is doing, that kind of constitutional practices have to be done. There's nothing wrong if the governor has called for the floor test instead of dismissing the chief minister directly, which happened in 1984 in Andhra Pradesh. So in Andhra Pradesh, what happened in 1984 is N.T. Ramarao was the chief minister, who was just dismissed by the governor Ramlal, even without asking him to prove his majority on the floor of the house. So what the Maharashtra governor did is better than what Ramlal has done in 1984. What Maharashtra governor has done is asking the government to prove the majority, that is inviting for a floor test. So that is where the governor should have been allowed to perform their constitutional responsibilities. Governor should perform his job more constitutionally valid, not political discretionary powers, but constitutional discretionary powers have to be used. So hence the court allowed the floor test in the Maharashtra ordered by the governor in the Sunil Prabhu versus Governor of Maharashtra case 2022. So that should be the conclusion. And then the conclusion should say that every discretionary power is not necessarily controversial. Where the governor is using the discretionary power according to the constitution to ensure the constitutional governance, that should be allowed to be implemented. So this is what was done by the Supreme Court also in the Sunil Prabhu case. And the 4th question, there is no structure to hear the public in the process of selection. No principle is laid down. No investigation is made. And a sort of hierarchy prevails. So the statement is not directly telling anything about anything. It is just saying in the process of selection, no investigation. But the second part of the question will reveal this. That is, in this context of Judicial Appointment Commission, explain the relevance of adopting the British model of judicial appointments. That is in India. So this question can be relevant both for the separation of powers as well as comparison of Indian constitution with other countries. So because in Britain, they had a new organization called Judicial Appointment Commission that was established in 2007. Judicial Appointments Commission, based on similar model, we adopted a National Judicial Appointment Commission in 2014. But however, that was not allowed to be continued by the Supreme Court. And now there is another debate of re-establishing the system similar to the British pattern. So Britain law, there was no Supreme Court at all till 2007. Because the highest court of appeal in Britain was only the Privy Council in the House of Lords. Even before independence as well, district courts, the high courts, then Supreme Court was there. Supreme Court was known as the Federal Court, established by the 1935 Government of India Act. So after the appealing in the Federal Court, if you lost the case, you were still having an opportunity to further appeal. ఇప్పుడు ఇండియాలో సపోజ్ సుప్రీంకోర్టులో కేసు ఓడిపోయారు, and that will be the final. But before independence, if you were defeated in the federal court, you have the possibility to appeal in the Privy Council, which was a part of the House of Lords, that is, which is the upper house in the Parliament. And till 2005, there was no Supreme Court in Britain. In 2005, they made a law called Constitutional Reform Act. So this Constitutional Reform Act came into force in 2007. And under this Constitutional Reform Act of 2005, a Supreme Court was established in 2007. And the Supreme Court comprises the judges selected by the what you call as the Judicial Appointment Commission. They are an independent body. Suppose in the Indian judiciary, there are a lot of lacuna in the appointment of the judges. Because how the judges are selected? Judges are selected only based on the experience. They will not consider the merit. There is no consideration for the merit. Suppose there are 1,088 judges in the high courts, and around 5,000 judges would be the advocates are there who are considered to be the senior advocates across 24 high courts. Right? But what the qualifications required for the selection of the judges? Anybody who is having 5 years experience as a judge of high court, 10 years experience as advocate of high court. But the judiciary is selecting through the collegium several judges of the Supreme Court without showing any basis. On what basis these senior persons are selected? There is no clarity, there is no transparency in this regard. Collegium is selecting and president has to appoint. Therefore, even the people like P.D. Dinakar and Samvitri Sen were also recommended to appoint as the judges of the Supreme Court, who are facing the highest levels of judicial corruption. So, therefore, the government came up with the idea of NJAC, but that NJAC was declared invalid. And so, in this context, there is a need for adopting the Judicial Appointment Commission mechanism in Britain that was constituted in 2007 and was improvised in 2013. So, according to which judges of the Supreme Court in Britain are appointed based on the merit, not only the seniority. Merit is also considered. Merit will be tested based on an examination. A merit test is conducted, just like the exam is conducted for the selection of the judges at the district level. District magistrates are selected based on the merit. Similarly, the judges of the High Court and the Supreme Court should also be selected on the merit. And there will be a test, a written test will be there, then there will be a group discussion followed by an interview. Only after this thorough scrutiny that the judges in Britain are selected. And not only the judges in the Supreme Court are selected, and they are selected by a Judicial Appointment Commission having almost 15 members. And all these 15 members, among these 15 members, a few members are selected, even the members to select the judges are also selected by the merit principle only. And apart from that, there will be representatives across all the counties in the British Isles. That is, there are several counties in Britain. From each county, there will be representatives in the Judicial Appointment Commission. Similarly, a Judicial Appointment Commission has to be established in India, in which there should be representatives from the Supreme Court in the form of Chief Justice and 2 senior most judges, Union Law Minister, opposition party leader in the Lok Sabha. And there should be representatives from all the states as well. Then the original National Judicial Appointment Commission also, the representation is very limited. Supreme Court is a federal agency. And federal agency, which is supposed to protect the interests of the states and the union government. And the selection of the judges should be in such a way that even there should be a participation of the people or representative of the people. And there should be representatives in the Judicial Appointment Commission from every state as well. That can be in the form of every state High Court Chief Justice should be a part of the National Judicial Appointment Commission. It should not be the one which was there in 2015. So in the 2015, the size of the Judicial Appointment Commission was very limited, 6 members only there. And the new body to be constituted should comprise of at least 30 members. With the mutual consensus among these 30 members. 30 members and one judge from each High Court, Chief Justice from each High Court should be a part of the NJAC. And the original composition of the NJAC together would be 30 members. And when there is a consultation and consensus among all the 30 members, selection of the judges would be more transparent. So that judicial selection should be based on such a transparent method and accountable mechanism. In the present system, how judges are selected and on what basis the judges are selected, nobody knows. Because collegium decisions are completely secret. The internal proceedings based on which they are selecting the judges, nobody knows. Whether they are conducting a group discussion, are they conducting an interview or a written test, nobody knows. So therefore, what can be observed is most often we see the judges in the Supreme Court who are either relatives of the existing judges or the people who have done the lobby within the judicial system. So the lobbyists are the relatives of the existing judges who would become the judges of the Supreme Court. So therefore, it is necessary that a model similar to the Judicial Appointment Commission in Britain has to be adopted in India also. Then the fifth question is about the ordinances. Are we living in the age of governance by ordinance? Governance by ordinance means administration by the ordinance in a democracy, which is ordinance power is most undemocratic power. Because democratic countries will not allow the ordinances kind of things. Only in India we have this ordinance kind of system. The other democracies like Britain and America, they have no provision for the ordinances. And explain whether ordinance is misused or used to meet the exigencies. The Constituent Assembly has provided the provision for the ordinances only to meet the exigency. Exigency and a situation that has arisen out of an emergency. Emergency should not be understood in terms of only war or internal rebellion. So exigency, it is a kind of exigency where you have to take an immediate decision. Because when the government has to take an immediate decision, it is difficult to let the parliament meet. Because there are 543 constituencies in the country. Arranging a meeting of parliament would require at least 1 month advance notice. Because people, all these 543 representatives from across the country cannot attend the parliament immediately on immediate footing. So they have to be given notice. They have the government has to make arrangements for their residential purpose every time, and various other arrangements, security arrangements need to be tightened. So it is not so simple to arrange the meeting of the parliament whenever you require. So therefore, to meet such kind of exigencies, the members of the Constituent Assembly have decided to give the governor at the state level and the president at the union to issue the ordinances. But however, this is often being misused by repromulgating the same ordinance again and again. So repromulgation is the most dangerous thing, which was not imagined by the members of the Constituent Assembly. Constituent Assembly members thought that 4 weeks would be adequate actually. 4 weeks would be adequate to issue an ordinance after issuing the ordinance to be approved by the parliament. But however, they have agreed to allow the parliament to approve the ordinance after 6 months. So the ordinance will have 6 months time. After meeting of the parliament, it would be approved within 6 weeks time. So, but what the government is doing, the government is repromulgating the ordinances repeatedly. So the example for the repetitive ordinances have been given in the introduction, like UPA government issued 61 ordinance between 2004 to 2014. And in just a span of 7 years, the NDA government has issued 76 ordinances. So crossing beyond the UPA record in just a span of 7 years. So it conveys a message that we are living in the age of ordinances, the governance by ordinances. So the infamous formulas were also actually enacted as an ordinance. CAA amendment was also implemented as an ordinance. And that is the Citizenship Amendment Act. Before it is being enacted into Act, it was an ordinance. And even the triple talaq prohibition was also issued as a repromulgated ordinance. The ordinance was issued in 2018 and it was repromulgated thrice. So they are the infamous incidents and of ordinance power of the government. So the president enjoys the ordinance power under Article 123 and governors under Article 230. So to meet the exigencies wherever the government is required. But however, this is being quite often misused. The government is misusing the power of ordinance for a self-interest. What should be the condition to issue the ordinance? When the parliament is not in session, ordinance can be issued. When the parliament is not in session means not both the houses also required. Even if one house is not in session, government can issue the ordinance. Because ordinance is having power equal to the legislature, law made by the legislature. And a law can be enacted only when both the houses are existing. So therefore, even if one house does not exist, is not in a meeting, government is empowered to issue the ordinance. So usually what we study in the textbooks is ordinance will be issued by the government, by the president, when the parliament is not in session. But what actually the government is doing, by proroguing the parliamentary sessions, the government is issuing the ordinance. If the government is thinking that there is no possibility of getting a bill enacted by the parliament, even if it is introduced in the parliament. So therefore, government is manipulating this power by proroguing the house before issuing the ordinance. That today, even if the parliamentary session is ongoing, they prorogue the house, an indefinite postponement of the house. And after proroguing, tomorrow they will issue the ordinance. And that ordinance will have 6 months time. And after 5 months, 30 days, that the president will issue an order dissolving the existing ordinance, and the same ordinance will be immediately repromulgated. So like that, same ordinance can be promulgated for any number of times, not just twice or thrice. For any number of times, it can be promulgated throughout the 5-year period of parliament. So the ordinance have been quite often misused. As I said, just because they are getting misused, you need not do away with the practice of issuing the ordinance. So there is a need for certain constitutional restrictions on the ordinance. Ordinance should not be renewed for a second time. And there should be a possibility of judicial review even on the ordinances as well. Because so as of now, ordinances are not open for the judicial review. So therefore, Supreme Court has given several directives in this regard in the DC Vadhva case in 1987 and in Krishna Kumar versus Bihar case in 2017. Even states are also not an exemption to the misuse of the repromulgation of ordinances. Suppose in Kerala, in 2020, 81 ordinances were issued. And in Karnataka, 24 ordinances were issued. Maharashtra, 21 ordinances are issued. Only in single year examples here. Only in 2020, 81 ordinances in Kerala alone is not a normal situation. Usually, communists would be criticizing, communist intellectuals would be criticizing the government for various things, including issuing the ordinance. The same communist intellectuals who are in power in Kerala, they have issued 81 ordinances. They always criticize the government for lacking the democratic orientation. But what about this democracy in Kerala? They don't think about the democracy in Kerala where they are ruling themselves. So how to control this? In the conclusion, you should say that legislature and judiciary have to take the initiative to impose limitations on the ordinance making power. Otherwise, they will also be responsible for killing of democracy. Because by not checking the practice of issuing the ordinances, re-promulgating the ordinances, legislature and judiciary are also abdicating the responsibility of constitution. So it is their responsibility to see that the democracy survives. So that should be the conclusion. So in various mechanisms that the ordinances are being misused, politically misused, and therefore there is a need for enforcing the Supreme Court judgment in this case. Right. Then sixth question. Now it is official that there are nearly 4 crores cases pending in various courts in the country. The reasons are exorbitant. How far national litigation policy handle this issue? Suggest further measures. So national litigation policy was announced in 2010 to minimize the litigations from the government side. Because out of these 4 crore cases, at least 3 crore cases are the state cases. State cases ante either government is filing cases against the people or people are filing cases against the government. They are the state cases. The biggest litigant in the country is the government, the state itself. The government is not the country, but the people holding the positions of the government, who are the bureaucrats. It is because of the egoistic bureaucrats, the number of cases in the Supreme Court or High Courts or in the district courts are piling it. So therefore, we have seen in the recent times that the High Court of Andhra Pradesh and High Court of Telangana enforcing judgments, giving the judgments even by imposing the punishments to bureaucrats, senior bureaucrats in the state. Most recently, 5 senior bureaucrats in Andhra Pradesh were imprisoned, was imposed with the imprisonment of 6 months each. And even in Telangana also, so Telangana state government has imposed imprisonment to several bureaucrats. Because these bureaucrats, because of their egoistic nature, they are enforcing the court judgments also. And this egoistic nature of the bureaucrats is also responsible for seeing that the cases are piled up in the Supreme Court and the High Courts and the lower courts. So out of the 4 crore cases, only around 70,000 cases are there in the Supreme Court itself as of April 2022. So 70,000 cases is not a small number. It was 60,000 in 2020, and in just a span of 2 years, the number of cases has increased to another 10,000. That is indicating that continuously the case pendency is increasing every time. So where you have to write about the reasons for the cases, increasing cases, and the consequences thereupon, and measures to be taken. So what are the factors responsible for this? The state is the biggest litigant. That is the fundamental factor. And it is due to the personal whimsical fancies of the egoistic bureaucrats. The cases are piling up in the courts. It is not the political executive which is filing the cases. It is only the bureaucrats who are actually filing the cases in the government. Or against the people, or the people are filing the cases. They are not ready to resolve the cases with simple solutions. And it is because of this egoistic nature of the bureaucrats who are responsible for increasing cases only that the government has came up with the national litigation policy, in which it was suggested that petty issues should not be taken to the courts. The national litigation policy suggested that the very petty issues, in which petty issues that if an officer is responsible to perform a job, he is supposed to do the job, but he is reluctant to do the job. Or suppose a municipal commissioner, if there is a municipal commissioner, it is his responsibility to see that the city is clean. He has to ensure the cleanliness of the city. And suppose if the city is not clean, it would be the responsibility of the commissioner to take that activity by one means or the other. Suppose if the municipal workers went on strike, suppose as happened in 2013 in Hyderabad, when GHMC employees went on strike because they were participating in the Sakala General Assembly. In the Sakala General Assembly, all the employees of the government were participating in the strikes. And even GHMC employees were also participating in the strike because they were demanding for a separate state. So in that context, for almost 30 days, JHMC workers were not cleaning the roads. And it was the responsibility of the GHMC commissioner to see that the roads are clean, because it's a matter of right to life. The roads are not clean. So when someone went to the court seeking a mandamus writ against the GHMC commissioner, the commissioner said that since the workers are not coming to the job, I am not able to ensure my duty, because it is his duty to do the job, to make sure that the roads are clean. He was trying to escape the responsibility, saying that the shifting the responsibility to the completely the employees. But the court rightly said that whether they went on strike or not, it is not the responsibility of the people. It is your responsibility to see that someone would be working. Otherwise, you have to do the work. And therefore, this egoistic kind of bureaucrats were escaping the job in one way or the other. And lack of full quorum in the courts. That is, the courts are having too many vacancies. Lack of clear legal arrangements regarding how to tackle the piling up cases. Then unreasonable thinking on part of the government before issuing a GO. The state governments are issuing the GOs without proper legal advices. And as a result, it will result in various legal complications. And people will file cases. And lack of legal expertise in the government. Then growing number of public interest litigations, because the people, more and more number of people becoming socially conscious. Because of the social consciousness, for everything, people will file the public interest. And even some people wanted to become famous. Those people who wanted to become famous also filing the public interest litigation. Therefore, the Supreme Court has commented on this kind of tendency as publicity interest litigation. The people who wanted to file the cases in the court for publicity, they wanted to become famous if they file a case in the Supreme Court. And disruptions due to the coronavirus pandemic, because during the pandemic time, almost 3 months the court did not function. Even after the pandemic lockdown also, the court directly has not functioned. It was working only online. So this disruption due to the lockdown has also increased the piling up of cases, because the disposal of the case rate is very less during the lockdown time. And government is not quickly clearing the proposals of the collegium in appointing the judges that happened between 2015 to 2021. And even now also around 40% of the vacancies are existing in the high courts. Only Supreme Court has complete full quorum of 34 judges. But still high courts are having 40% vacancies. Then frequent appointment, adjournment of the cases. And adjournment of the cases is done by the, not by the lawyers, but by the judges. Lawyers would be seeking the adjournment and judges would be giving the adjournments. But whether there is lawyer or not, if the judge thinks, he can give the judgment. So therefore, if the adjournment of the cases is avoided, the piling of the cases at the district level can be prevented. Because district level, what happens is, in the district level, a district court lawyer would be taking up several cases. And the lawyer would be busy with fighting the cases across various courts within the same area, within the same locality. And as a result, the lawyers will seek the adjournment of the cases on one hand, or the clients will be seeking the adjournment of the cases only to delay the case, to see that the witnesses in a particular case will die. If the witness is died, and there is no possibility of imposing the punishment in the case. So even on those lines also, in several criminal cases, the clients and the lawyers will see that the case is postponed for a long time. So these are the various number of reasons that this issue can be a question even in the general essay also. The judicial delays, justice delayed is justice denied. On those lines, a quotation can be given. And what would be the consequence of pendency of the cases? There has been a sharp spike in the pendency of the cases, and which has resulted in an increase in the number of under trial lodged in the prisons. So 76% of the total inmates in 1300 prisons were under trial prisoners. Under trial and against whom the accuses are not proved. So increase in the number of commercial disputes is also one of the consequences. Commercial disputes means disputes with reference to the business, and because of which negative effect on the trade and commerce is also happening. And the people from abroad, those who are interested to provide their investment in India, the foreign direct investors are not showing interest to provide FDIs in the country because of the judicial litigation, even with reference to the labor cases arising out of the labor disputes, and even the commercial disputes arising out of labor classes, or the disputes with reference to the local pressures. Everything would be piling up the cases, and if these disputes are not resolved quickly, foreign direct investors would not be ready to provide their investments. And in this context, national litigation policy was enacted in 2010 for a quick disposal of the cases. It was also insisting upon disposing the litigation without taking it to the court. Out of the court route should be adopted. Out of the court route means not taking a case to the court. As far as possible, there should be a compromise between the two parties if there is a petty issue. So where the officer has to perform his responsibility as an obligation should not be avoided. So on those lines, this national litigation policy has been proposed, but still pending cases are continuing to exist. Hence, there is a need for taking up several further measures, like batch-based disposal of the cases is required. Batch-based disposal, suppose most of the under trial prisoners in the courts, in the jails, are facing the petty cases of theft, in which not more than 3 months imprisonment can be possible. Suppose a pickpocketer would be imposed with 3 months imprisonment. A liquor peddler, like in the states like Gujarat or in Andhra Pradesh, a liquor peddler and those who are smuggling the liquor would be imposed with 3 months imprisonment. So all these cases, if you steal something in your neighborhood, you'll be imposed with 3 months imprisonment. If you steal something from a shop and you are caught in the CCTV camera, 3 months imprisonment. All such cases can be disposed together in a single batch. That is the batch-based disposal of the cases. Like encouraging the people for the adoption of more alternative dispute resolution mechanisms. And Lok Adalats have to be encouraged. Lok Adalat, this is a kind of compromising between the two parties. This is a Lok Adalat system. And filling the vacancies immediately, e-court system to be adopted more, then establishing the tribunals and special courts, creating more number of fast-track courts, and increase the number of working days. Like the schools, the courts are also taking the leaves. For the schools, we have summer holidays, winter holidays, midterm holidays. Similarly, the courts will also have all the 3 types of holidays. So the courts should also have more number of working days. So there is a need for creating an all India judicial service. Even all India judicial service and question. Because if the all India judicial service is created, there will be a continuous supply of the judges every year at the district level, who would be promoted to the next level, High Court and Supreme Court. So that would helpful to increase the judge to population ratio. Then what is the need for establishing separate Ministry of Cooperatives? Do you think that it is a federal practice? So, because in 2021, the Union government has created a new Ministry of Cooperation with Amit Shah as the in charge. So it was proposed to establish a separate ministry in the union budget itself. And according to those proposals, the Union Ministry of Cooperation was constituted. So this issue of federal practice arises because cooperative matters are a matter of state list. But however, the opposite opinion is interstate cooperatives is a matter of union list. Hence, the union government can take the initiative to constitute the cooperatives. Suppose Amul is a interstate cooperative fertilizer, interstate cooperative society, the biggest cooperative society in the country. So to promote the ease of doing the business and to promote the multi-state cooperative societies, the Union Ministry of Cooperation was constituted. Political requirements may be different. There is a political ideology behind establishing a Ministry of Cooperation. Because in Gujarat alone, there are around 2 lakhs cooperative societies with almost a membership of 2 crores people, which is a potential vote bank for the government. So if they are manipulated, there will be a potential vote bank in Gujarat alone. So opposition parties are saying there is a political intention behind establishing the Ministry of Cooperation. But however, we have to focus only on the intended objectives. What is the intended objective? That is strengthening the cooperative movement in the country and streamlining the process of cooperatives, realizing the vision of Sahakar se Samruddhi. Sahakar se Samruddhi means development through the cooperation. Because even in the farm laws also, one of the provisions of the farm laws is to make sure that the small land holdings will be converted into a huge land holding. Cooperative agriculture will ensure even achieve that objective also, converting the small land holdings into huge land holdings so that contemporary technologies can be used in the farming as well. When the land holding is very big, you can use even the drones and for various multi-purpose activities. And information technology can be used, artificial intelligence can be used. Once upon a time, in the textbooks, we used to read like farm mechanization was confined only to introducing some machines like tractors or boring pumps. But now we are thinking about beyond that mechanical machines. Now we are thinking beyond this means using the artificial intelligence, using the robotics in the farming, where the minimization of the requirement of the human labor is reduced, and huge utilization of the drones is possible. So whatever the technologies that we are considering the contemporary, including the Internet of Things, all those wireless technologies can be used even in the farming as well, when cooperative movement in the farm sector is improved. So with those objectives, the new Ministry of Cooperative Societies is being created. And what is the need for new ministry? To restore the importance of the cooperative structure in the country, because the cooperative movement was very famous during the 1980s. But after the liberalization period, the cooperative movement is gradually declining. And now the government wanted to restore the significance of the cooperative movement. And cooperative movement is successful only in the states like Maharashtra, Gujarat, and Karnataka. So the new ministry would expand the development of the cooperatives across the country and in all the states. And cooperative institutions get capital from the central government, either as a equity or as a working capital. So those issues are indicating that the cooperative sector was is required, immediate requirement for the agriculture development, or for the development of the forest sector, and or for the development of the industries, more particularly MSME, and to enhance the employment opportunities for multiple purposes, that the cooperative movement is required to be promoted. Cooperative movement can be adopted in the agriculture or in the industrial sector or in the financial sector. Even for the financial services also, cooperative movement is needed. So financial services sector, cooperative bankings. So there are so many cooperative banks. Suppose Mahesh Cooperative Bank, so which is very famous bank in Hyderabad. So such kind of cooperative banks. Bhagyalakshmi Cooperative Bank. Of course, because cooperative banks have manipulated the money in which they have been deposited. The popularity of cooperative banks were declined. And it is said that with the establishment of the separate ministry, more regulation over the cooperative banking systems will be created. And the cooperative banks will work with more efficacy. So, therefore, alongside the state and market, cooperatives will also play a vital role in the development of the country. Because cooperative societies are like third sector, voluntary sector, participative sector. And cooperatives అంటే దాంట్లో మెయిన్ మెంబర్స్ ఎవరు, neither state nor market. The members are the people, civil society representatives. So therefore the cooperative societies are needed as a third active sector in promoting the growth and development economically of the country. The eighth question is about the what is executive clemency? Is it politically misused? Explain the judicial stand on this. The judicial executive clemency and the pardoning power of the president and the governors at the state. So it's the pardoning power granted to the president under 72 and 161 under to the governor. So is it politically misused? And definitely it is politically misused. Reason is how it is politically misused. By postponing the decision about the pardoning or by speeding up the decision about the pardoning. So this is very much clearly visible in the context of Pirari Valan case in the one who is accused in the Rajiv Gandhi assassination. So in that context, a probable question may be given on the executive clemency. So it is politically misused. Various political parties in Tamil Nadu were supporting pardoning of this person who was responsible for death of 44 persons. Along with Rajiv Gandhi in this assassination, innocent people, 44 innocent people were also killed. And this person who is responsible for the death of this were supported by the political parties, every political party in Tamil Nadu, because he is a Tamilian from Sri Lanka. And they are saying that he was not a terrorist, he was only an activist. He was only a rebel, but not a terrorist. That is from the point of view of Tamilians. But from the point of view of remaining people, he is a terrorist. And that is where the politicians in Tamil Nadu were supporting the pardoning of this person. The government at the union is also equally manipulating this by delaying the pardoning. By delaying the pardoning means when in 2018, when the governor was asked to pardon, governor has transferred this file to the approval of the president. And the president has kept this in abeyance since 2018 without taking any decision. Of course, meanwhile, the Supreme Court has interfered, saying that a complete justice has to be done under Article 142. And to ensure the complete justice and to protect the human rights. This person has been released by the court itself, a new situation whereby the pardoning power of the president is being taken away by the Supreme Court. So this is a biggest peaks of judicial adventurism in the name of the complete justice under Article 142. The pardoning to be provided by the president or the governor is done by the Supreme Court, saying that the human rights of this person is being violated. If the human rights of the person accused is to be protected, then what about the human rights of the people, the relatives of the people who were killed in the assassination of Rajiv Gandhi? They say that it's a matter of, as a revolutionary, as a matter of collateral damage, it may happen. But it is not a simple thing to consider this to be a collateral damage. So the purpose of the executive clemency is to see that there will be no human errors in delivering the justice. But usually government is misusing this power by delaying the decision of pardoning or pardoning the political prisoners. Suppose there was a person in Andhra Pradesh, Gauru Venkat Reddy, an MLA, who was imposed with a life imprisonment. and has been released by pardoning just because he was a friend of Rajshekar Reddy. So his punishment has been turned down by using the pardoning power of the governor, or even by rejecting the pardoning also, that the government can enjoy this power, can politically misuse this. As in case of Afzal Guru. Afzal Guru has applied for a pardoning, the one who is responsible for attack on parliament, terrorist attack on parliament in 2000. Allen. So the pardon has been rejected. That is to show the world that the Congress government will not excuse the terrorist. So on those lines, there are various possibilities of manipulation. Supreme Court in several judgments, including Maru Ram case, Swaran Singh case, Kehar Singh case, and Kehar Singh ante the one who assassinated Indira Gandhi. Like a Dhananjay Chatterjee case, Sudhakar case. Sudhakar ante the one who questioned pardoning of Gaurav Venkat Reddy in Andhra Pradesh. Like a Perari Valan case, the one who is an accused of terrorism, assassination of Rajiv Gandhi. So in all these cases, the common thing that the court has proposed is whenever there is a political misuse of the pardoning power, the court will interfere. Usually the presidential power is beyond the intervention of the court. But the court said the court will interfere through the judicial review. And in the Perarivalan case, the court itself has granted the pardon because the president is delaying it. So those guidelines given by the Supreme Court in various cases would be useful to prevent any possibility of misuse of the pardoning power for political reasons. So generally, we consider the Prime Minister as primus inter pares. Textbook lo undedi. First among equals. But this question can be given, like Prime Minister is more than primus inter pares. Not just a primus inter pares. Because when the post of Prime Minister actually created after the cabinet. Because in 1688 in Britain, after the glorious revolution in Britain, the concept of cabinet has emerged. 100 years later, in 1799, first post of Prime Minister has been created. And that means the post of Prime Minister is later. And even in the Indian Constitution, if you look at the Article 74, it says that there shall be a Council of Ministers. It is not saying there shall be a Prime Minister. But Article 52 says that there shall be a President of India. And 74 law, there should be a Prime Minister. But instead of saying that, there shall be a Council of Ministers with Prime Minister as the head of it. That indicates that the Prime Minister is one among the ministers who is just a leader but not a boss. Prime Minister is a leader but not a boss of the cabinet. And he is just a first among equals. All the ministers are equal along with the Prime Minister, but the Prime Minister stands at the top. So what the Prime Minister will be doing as a first among equals, as a primus inter pares, selecting the ministers, recommending the president to appoint the ministers, asking the president to allocate them the portfolios, reshuffling the cabinet. If any minister is not agreeing with the collective responsibility, asking the minister to resign. If he do not resign, asking the president to dismiss the minister. And as a first among equal, Prime Minister is doing all these jobs with reference to the ministers. But in reality, the Prime Minister is more than primus inter pares. So how the Prime Minister is more than primus inter pares? Because he decides life and death of the cabinet. If the Prime Minister resigns, the entire cabinet is considered to be non-existent. In case of the resignation of the Prime Minister, one among the cabinet minister cannot become the Prime Minister. As soon as the Prime Minister resigns, cabinet also resigned or considered to have resigned. So he is deciding the life and death of the cabinet, and he decides the policies despite the presence of the ministers. when we think about the socialistic policy, socialistic pattern of society, we think about the Nehru. When we think about LPG, we think about PV Narasimha Rao. And all these famous economic policies, despite the presence of the finance minister, we only consider the prime minister as a primary personality. అలాగే ఫారెన్ పాలసీ కూడా ఇప్పుడు పంచశీల్ అంటే we don't think about the foreign minister existing at the time. We think only about Nehru. Non-alignment movement అంటే we don't think about the foreign minister. We only think about Nehru. Make in India campaign అంటే we don't think about the foreign ministers but only Narendra Modi. So only now with the after Jaishankar has taken as a foreign minister, the foreign ministry has got a little bit of recognition. And so therefore, even despite having a separate ministry for every department, all the policies are issued in the name of the prime minister. And prime minister taking the assistance of the experts and professionals rather than the ministers. This is also empowering the prime minister to emerge as a larger than the life size. So the prime minister office is a super cabinet that has established the credibility of the prime minister as a superhero. The prime minister is almost like a Superman, and he emerged as a Superman because of the PMO. Without the support of the PMO with 350 IAS officers behind him, it would not be possible for the prime minister to emerge as a superhero. So the credibility of the prime minister going beyond the primus inter pares established by all these factors, including the charismatic leadership of the prime minister in the public support. People are voting the prime minister, but not the party. If the people have voted for the BJP, they are not voting for the BJP, they are voting for the Modi, Narendra Modi. That is the face of the party, right from the beginning. Either Nehru was the face of the party, or Indira Gandhi was the face of the party. And then in the UPA government, Sonia Gandhi was the face of the party. Of course, the prime minister was different. Sonia Gandhi was acting like a shadow prime minister or super prime minister, a prime minister over the prime minister. And now Narendra Modi is the face of the party and emerging as a charismatic leader. So therefore, the people are actually voting the person, but not the party as a whole. So hence the cabinet government is often described as a prime ministerial government. Parliamentary government has transformed into a prime ministerial government because of the super nature of the prime minister. And the 10th question, though indirect, the election of the president is so framed that he is perfectly representative in character. So that is about the election of the president. So because this July is the election year of the president, and a probable question may be asked about the presidential election. The president is elected by an electoral college through a proportional representation, which is an indirect election. So electoral college comprising of the members of Lok Sabha, elected members of the Rajya Sabha. But earlier there should be elected members of Lok Sabha, but after the 104th amendment, nomination of Anglo-Indians to the Lok Sabha is discontinued. And again, members of legislative assemblies of the states and members of legislative assemblies of Delhi and Pondicherry. So in the next presidential election, there may be even Jammu Kashmir also, legislative assembly of Jammu and Kashmir. Now there is no legislative assembly of Jammu and Kashmir because it is in a dissolved condition. So the method of election is indirect. That requires the winning candidate to get a minimum quota of votes. So the quota of votes will be calculated based on a formula, that is number of total valid votes divided by 2, the whole sum to be added with one more, and more than 50% is required to win the election. So that itself is indicating that the president would be indirectly also representing the nation, representing the people, representing the states. President is representing the nation because he is elected by the people people's representatives in the Lok Sabha and the state legislatures. Secondly, the president is representing the states because he is elected by the Rajya Sabha members. So even indirectly, the election of the president is more direct, more representative in character. So to achieve the uniformity in the scale of representation of different states and bringing parity between the states, these formulas have been constituted according to which the vote value of all the MLAs in the country are similar, irrespective of the number of MLAs. Vote value of MLAs in UP Assembly are more or less same as the vote value of the MLAs in Sikkim or in Sikkim meaning a legislature with the least number of MLAs, 32 MLAs. UP a legislature with highest number of MLAs, almost 403 MLAs. So the vote value of MLAs in UP more or less equal to the vote value of MLAs in Sikkim, which is almost 208. Vote value of all the states together, MLAs together, is equal to vote value of MPs in the union government, and which is almost 708 around. So that is where, despite being indirect, the election of the president is equally representing both for the states, people, and the nations. So there is no need for direct election of the president as being claimed by some people. Direct election cannot be adopted for the president. Presidential type of election cannot be adopted for the MLA and MP election, because this proportional representation will require knowledge of reading and writing and cannot be implemented for the general elections. Because when you have to vote in the election of the president, you have to read all the names and you have to write the preferences. 1, 2, 3, 4 preferences should also be written. But reading and writing knowledge is required. So there is no need for direct election to the post of the president. So that should be the conclusion. Because in a parliamentary democracy, we have not adopted a real executive in the form of president. A direct election of the president would be expensive, and a direct election of the president would result in conflict between prime minister and the president. To avoid those issues, the existing pattern of election would be adequate. So that is